afternoon. I'm Congressman Bobby Scott from the 3rd District of Virginia, and I am the lead Democrat on the Committee on Education and the Workforce. And I want to wish everyone a good afternoon and thank you for being here. Today, we face an unprecedented rollback of diversity, equity, inclusion, and accessibility that we've not seen the likes of since the 1960s. The Trump administration is working to undermine decades of progress towards stronger civil rights protections and expanded opportunities for people with disabilities. Now, October marks the National Disability Employment Awareness Month, in which we recognize the decades-long fight for equal employment opportunities for people with disabilities. We are here today because we believe in the fundamental truth that all people deserve the right to participate fully in their communities, the opportunity to earn a living and support themselves and their families, and the right to access the home and community-based services that they need to live and work in their communities. And we're committed to defending those rights. This administration has issued multiple proposals that would turn the clock back for Americans with disabilities. For example, the Trump administration has proposed to eliminate the Department of Education, the department created by Congress to protect and enforce students' civil rights and ensure that students with disabilities receive a free and appropriate public education. On Friday, almost everyone at the Office of Special Education and Rehabilitative Services received a reduction in force or a RIF notice. And it's unclear how the grants to states to fund special education or vocational rehabilitative services will go out, or whether anybody will be there to provide oversight or technical assistance to ensure that this federal funding will be used to support students with disabilities and adults with disabilities seeking employment and training. Additionally, millions of dollars in grants under IDEA Part D that supported training for special education teachers, resources for parents for students with disabilities, and services for disabled youth transitioning to adulthood have all been canceled. President Trump has also moved to close the Administration for Community Living, a vital office that implements, oversees, and provides guidance to key programs for people with disabilities. In August, I released a report detailing how the Trump administration has undermined key programs such as Centers for Independent Living, Statewide Developmental Disabilities Council, assistant technology programs, and others designed to support individuals with disabilities and older adults. In addition, approximately 1,200 Health and Human Services employees also received RIF notices over the weekend. In the first few days of his second term, President Trump rescinded Executive Order 11246, which has been the cornerstone of civil rights protections in federal contracting since 1964. This executive order required that federal contractors take affirmative action against discrimination, ensuring that taxpayers' dollars don't go to fund bias in the workplace based on race, color, religion, sex, or national origin. Although Section 503 of the Rehabilitation Act still requires affirmative action by federal contractors for disabled workers, rescinding Executive Order 11246 gave the administration an excuse to dismantle the Office of Federal Contract Compliance Programs, OFFCP, that enforces Section 503, and now the Department of Labor has proposed a rule that makes enforcement of Section 503 virtually impossible. Finally, the Trump administration is now poised to make it more difficult for individuals with disabilities to access Social Security benefits, eliminating age as a factor in evaluating disability claims. Currently, Social Security Administration does consider age, work experience, and education to see if a person can adjust to other types of work. Older applicants, typically over 50, have a better chance of qualifying because SSA recognizes that older workers may have a harder time adapting to many jobs. Determining eligibility for Social Security disability also impacts access to Medicaid benefits, including home and community-based services. But we're not here just to discuss the problems at hand. We're here because all of you are committed to fighting back against these attacks on diversity, equity, inclusion, and accessibility. During my time in Congress, I've spent years dedicated to realizing a full, integrated, and competitive workforce. Unfortunately, the 14C sub-minimum wage provision under the Fair Labor Standards Act is still in practice, allowing employers to legally pay workers with disabilities less than the minimum wage. The good news is that according to a 2023 Government Accountability Office GAO report, employer and worker participation in the 14C program is steadily declining. For example, my home state of Virginia, there's more than a dozen states that have passed legislation that gets rid of 14C by preventing the issuance of any new 14C certificates and phasing out existing certificates by July 2023. I'll also continue to fight for the bipartisan bicameral Transmission to Competitive Integrated Employment Act. This bill incentivizes states and employers who currently use 14C certificates to work with the disability community to upgrade business models and create fully integrated and competitive employment opportunities. It also increases the availability of integrated services and supports that not only make it possible for people with disabilities to work, but also fosters community integration. But the fight does not stop at Congress. The real change will take all of us coming together to achieve core goals of the Americans with Disabilities Act: equal opportunity, full participation, independent living, and economic self-sufficiency. So with that, I'm pleased to hand the mic over to Dante Allen, former Commissioner of Rehabilitative Services Administration during the Biden administration, who will introduce our panelists and moderate today's discussion. Dante?
Congressman Scott, thank you so much. It's a pleasure to make your acquaintance. I think we have a very interesting discussion scheduled for this afternoon. In light of time, I want to make the introductions as brief as possible. The bios are available to all of you participating, but we do want to allow each of our panelists to have some time to present and then get into a little bit of Q&A discussion. With that said, let me say, as the most recent presidentially nominated, Senate confirmed commissioner of the Rehabilitation Services Administration, that there is a great amount of anxiety and straight out fear about the condition of where things exist. The program that I was very recently in charge of taking hold of is now teetering on the brink of extinction. And the impact that that can and will have on individuals with disabilities across the nation is quite frankly unacceptable. So I'm very pleased today to have this group of folks that can come together and have a discussion about where we stand, to give a complete picture of what that impact would be and how we can engage together to ensure that we reduce and eliminate any burdens that are coming up. So let me start with introductions. First, I have Selena Almazan, who is the legal director of the Council of Parent Attorneys and Advocates. She'll talk this afternoon about the impact on education. I have Dr. Julie Christensen. She's the executive director of the Association of People Supporting Employment First, and she'll talk about the impacts on employment. I have Jennifer Mathis, the deputy director of the Bazelon Center for Mental Health Law, and she'll talk about law as applicable to mental health. And Aaron Prangley, who is the director of public policy at the National Association of Councils on Developmental Disabilities, who will give her impressions on health. One of our panelists, Jennifer Mathis, will not be able to participate in the Q&A. So Jennifer, let me turn it over to you first to give us a brief overview of your thoughts.
Sure, and I apologize that I am not able to stay past 3 o'clock, but I will give just a very high-level overview. So the folks on this panel will talk about some of the key actions that federal administrative agencies have taken during this administration that attempt to restrict or roll back the rights of people with disabilities. Some of them appear clearly unlawful to us, such as the near decimation of the Department of Education's Office for Civil Rights, which has always played a critically important role for kids with disabilities. And many of those actions are the subject of ongoing legal challenges. Other ones of these actions, whether lawful or not, really undermine the protections that Congress put in place for people with disabilities. So one thing I would just say that has really surprised many of us in the disability community has been the degree to which this administration has gone after employment protections for people with disabilities. As you know, employment of people with disabilities has always had strong bipartisan support and historically has been an issue or a set of issues that receive priority across all administrations because of the widespread recognition of the problems that we have historically faced with the underemployment and unemployment of qualified people with disabilities. But we are now seeing an effort to gut many of those employment protections for people with disabilities. For example, Julie Christensen will talk about Section 503 and the proposed rule that proposes to undo really the core of the key protections in Section 503 of the Rehabilitation Act, which is a set of protections that's critically important to people with disabilities because it requires large federal contractors who employ a quarter of the national workforce to take affirmative steps to promote the employment of people with disabilities. And with Section 501 of the Rehabilitation Act, which applies to the federal government and has similar non-discrimination requirements and also requires affirmative steps to employ people with disabilities, and in fact requires the federal government to serve as a model employer. We see right now steps that seem to go in the opposite direction of being a model employer. For example, we saw the CDC categorically remove remote work across the board as a reasonable accommodation, regardless of whether it was necessary for somebody's disability and whether it would be reasonable and has been historically used at the agency. That's not consistent with the law. That was temporary. It seems that they reversed themselves, but we understand that this is very much under discussion and still very much up at the air at CDC and elsewhere. With the EEOC, we saw the firing of 2 Democratic commissioners, despite the protections of the enabling legislation of the EEOC. Now we have we had one Republican appointed commissioner, one Democratic commissioner, and we just have a 3rd commissioner now. So now there is a majority for the commission to start acting, and we have some concern based on some of the things that have been articulated, including, for example, the pronouncement a few months ago that the commission would deprioritize disparate impact provisions across the board. And in Title I of the ADA, disparate impact is in the statute, specifically in the statute in multiple ways. And so that is very concerning. There is some irony in the fact that Congress has required people to comply with community engagement or work requirements in Medicaid in order to keep receiving the services they need. And that is expected to result in 5 million people or so losing Medicaid coverage, even though the majority already work, but are expected to lose coverage due to the complexity and red tape of repeatedly demonstrating compliance with those work requirements. And of course, without the services they need, will have more difficulty working. But against the backdrop of the narrative, that narrative of work and the importance of work, it is more than a little ironic that this administration seems to be taking one action after another to reduce the employment of people with disabilities. And so I will leave it there. I won't talk about mental health, but I'm happy to because there's just not enough time, but happy to have anybody follow up with me if they would like. And I will turn it back to Dante.
Thank you so much for that overview. And in the interest of time, I want to turn it over to Ms. Amazon and give you some time to provide similar thoughts.
Thank you. Thank you, Dante. Thank you, Jennifer, and thank you to Congressman Scott. I am the legal director for the Council of Parent Attorneys and Advocates. We are a nonprofit organization of advocates, attorneys, and parents who work on issues related to students with disabilities in K-12. This administration, by seeking to dismantle the United States Department of Education and taking active steps through pursuing these massive layoffs that include all the offices of the Education Department, including the Office for Civil Rights and the Office of Special Education, the closing of the regional offices and limiting civil rights investigations, withholding and canceling authorized key education, research, and technical assistance funding, and proposing to eliminate provisions in data collection that focus on race, the administration has and continues to jeopardize equity in education for all children who attend their neighborhood public school, especially students with disabilities. The recent additional actions to decimate the Education Department workforce are contrary to the legally mandated role of the Secretary of Education, who Congress, through the Individuals with Disabilities Education Act, the IDEA, 504, and other education statutes, has intentionally and specifically directed the Secretary of Education to fund, oversee implementation, monitor accountability and compliance, and lead activities so states can meet the key requirements of federal education laws. Specifically, the Education Department is required in the Elementary and Secondary Education Act to advance equity by upholding critical protections for America's disadvantaged and high-need students, and in IDEA to provide a free, appropriate public education in the least restrictive environment for all students with disabilities. It is the critical intersection of our nation's education and civil rights laws, the ESEA, Section 504 of the Rehabilitation Act, and IDEA, which ensure that each child in the United States, regardless of race, income, ethnicity, disability status, can access a K-12 education. Today, we know that more than 80% of all children attend a public school, which means the Secretary plays a major role in ensuring public schools can educate most of the America's 7.5 million school-age students with disabilities. COPA has actively opposed any effort to dismantle the U.S. Department of Education and any effort to move IDEA to HHS or any other agency. The cumulative effect of these actions is that without the United States Department of Education to intervene, we are concerned that the family's only recourse to enforce these laws will be through the court system, and that will be a tremendous burden on families who already continue to raise children with disabilities. We know that the majority of students with disabilities live in poverty, so this is an additional burden for families, and it strikes at the very heart of the civil rights laws. Thank you.
Thank you. We'll open things up for questions, but let me turn it over to Ms. Prangley. Would love to hear your thoughts and overview.
Thanks, Dante. And good afternoon, Ranking Member Scott. Thank you and your staff, especially Phoebe Ball, for organizing this important civil rights oversight hearing. The Virginia Board for People with Developmental Disabilities, I'm sure, would be pleased to extend its thank you as well, Ranking Member Scott. I know you and your constituent office have a very good relationship with the state council in your state. And we do so much appreciate your work on the Transportation for Competitive and Integrated Employment Act. As Dante mentioned, I represent the federally authorized and annually appropriated state councils on developmental disabilities. All the staff in this webinar, you need to know that your state has a state council of developmental disabilities. If you have any questions about issues that are raised today or in the course of your work for your member, please do not hesitate to reach out to your state council on developmental disabilities, as they can provide on the ground, up-to-date information on how these federal policies are affecting your constituents. So let me jump right into it. The councils have been around for over 50 years. I like to think of the councils in the disability rights movement kind of like Taylor Swift described her Eras tour, right? She said, she was asked, how did you do this? And she said, you know, this tour was the result of decades of meticulous planning and moments of serendipity. You all on this call are the beneficiaries of the work of Ranking Member Scott and several before you to inform people about the importance of civil rights for all, including people with developmental disabilities. I just want to put that in context because I remember starting as a staffer for Eleanor Holmes Norton back like 30 years ago, and disability was in my portfolio. But I never went to school with anyone with a disability. I never really thought of my family having a history of disability. Well, guess what? 30 years later, I know now my daughter goes to school with people with disabilities. And that's because of the work of Ranking Member Scott and other really important civil rights leaders to make sure that we had legislation passed. My family, actually, my parents had cousins who were institutionalized for learning disabilities. And one of them, unfortunately, committed suicide in one of those institutions. I now know I have several cousins with developmental disabilities themselves or children with developmental disabilities. None of them are in institutions because we value and we recognize the years of meticulous planning that went into the realization of statutes like the Americans with Disabilities Act, right? And we also recognize the serendipity of the Americans with Disabilities Act being signed by a Republican president who had an ear because of his personal experience and because of fantastic work by advocates for advancing the rights of people with with disabilities in general, and in particular, people with developmental disabilities. So let's keep this all in context. Disability movement is strong in our country, especially in your states. The state councils on developmental disabilities have played a key role in implementing those civil rights laws at the state level. The state councils have received bipartisan support through annual appropriations, reflecting the value of our work in applying these ideals that the congressman mentions of the Americans with Disability Acts and others to the actual work on the states. Because of course, we know that many of these issues we're talking about, from education to healthcare and others, are really primarily implemented in the states. Still, 35 years after the passage of the Americans with Disabilities Act, it's really preposterous to argue that our country has fully achieved the goals of the Americans with Disability Act of equal opportunity, full participation, independent living, and economic self-sufficiency for people with disabilities. You've heard from the panelists, I'll just repeat a little bit, but people with disabilities continue to face the systemic barriers, including about 1 in 5 are employed full-time. Nearly 25% encounter obstacles while voting, and students with disabilities lag far behind their peers in graduation and post-secondary outcomes. So these disparities reflect these ongoing civil rights challenges that demand federal attention and enforcement. States need more support, not less, from the federal government. The states cannot do it alone. And our work now at the federal level is just as important as ever. This state-federal partnership is critical. That's why the state councils on developmental disabilities are so concerned in recent months about these executive orders that have diminished and denigrated our federal civil rights laws. If they haven't done it explicitly by name, calling out disability, then they certainly have diminished and denigrated disability rights by their intention. Our federal civil rights laws remain the law today, but these executive orders and shifting federal funding priorities risk stripping all these supports and rights from people with disabilities in the states simply because of their disabilities. And they threaten to turn back the clock on the decades of progress that we've made in the disability civil rights movement. These decades of meticulous planning, the blood, sweat, and tears by Ranking Member Scott and many of his colleagues to make this happen. So our state councils are urging members of Congress to reject the rollbacks of any federal protections for people with developmental disabilities, but we need that strong leadership from Washington. It's critical to empower the states to remove barriers so that they can continue to ensure equal opportunity, full participation, independent living, and economic self-sufficiency. Our councils remain deeply committed to protecting and advancing civil rights laws for people with intellectual and developmental disabilities. I look forward to your questions, and I hope to help facilitate future conversations between you and your offices and the state councils on developmental disabilities about how what's happening in Washington right now is affecting their everyday lives. Thank you.
Thank you so much for your insight. I'll turn things over finally to Dr. Christensen. I'm very anxious to hear your thoughts on the potential impact, the erosion of protections that we had to ensure that individuals with disabilities have the rights to employment.
Yes, well, thank you. And I want to echo the thanks to you, Congressman Scott, to your team, and to my co-presenters. Wow, I don't know how to follow up on what folks have already said, but let me just start by recognizing, as you did, Mr. Allen, at the top of our time together, that it is National Disability Employment Awareness Month. It's a particularly difficult time when we have this month set aside that is usually sort of a culmination of celebration of forward progress. Even if incremental, there's always progress. And it feels different this year. And that's really hard to take. So let me just quickly tell you elevator speech about APSE, the Association of People Supporting Employment First. We're a national member organization, and we are cross disability. We are cross systems. Essentially, the membership eligibility to be part of APSE is that in some aspect of your work life, you are actively working to eliminate barriers to employment for people with disabilities. So our membership's broad. It's K-12 education, it's healthcare workers, it's policymakers, funders, and the core of our membership is employment support folks. So your job coaches, your job developers, your folks who are on the ground every day, working with business communities, helping people with disabilities connect to assistive technology, supports that they need, training, you name it. And, you know, when I think about the things that I typically say when I'm asked to speak during Disability Employment Awareness Month, it is a very tenuous time. So I know, Mr. Allen, you mentioned the cuts to Rehabilitative Services Administration, and I'll talk about that in a second. But I also want to acknowledge that, you know, some of what has happened that has really impacted disability employment really began right off the bat in January at the start of the administration, including significant cuts to resources to the Office of Disability Employment Policy at Department of Labor, who sponsors Disability Employment Awareness Month nationally. So I want to give a shout out to the ODEP team, who continues with increasingly limited resources to continue to be that voice within the federal government to point on some of these issues. So here's what we do know, and we have the data and the research that backs this up. When people with disabilities are working, the trickle-down effect of that crosses multiple systems, crosses multiple funding streams. There's no argument that the return on investment for federal dollars spent comes back multiple times over. People with disabilities, when they're working, have better healthcare outcomes. They have better mental health outcomes. They have access often to employer healthcare that allows them to not have to rely on some of our, federal, for lack of a better term, safety net systems. The ability to not have to rely on Social Security, SSI, SSDI, because people are able to make a living wage. People, even with the most profound disabilities, can work. We see it every single day. But that doesn't happen in a bubble, right? It happens because we have these systems at the federal level that are the model or should be the model for what then trickles down in states for implementation and all the way down to local communities. And what we're seeing right now is that we've lost that model. Jennifer mentioned in her opening about what's happened with Section 503 of the Rehabilitation Act. I mean, that's a great example where Section 503 was an opportunity for our federal government to model and implement the full intent of current law, which says that people with disabilities should have access to the workforce, and to eliminate those rules that helped keep a check in place to make sure that we were doing what our laws say that we should be doing, sends a signal, intentional or not. It sends a signal that we don't prioritize what is already in law. And I think, that's a recurring theme in our concerns with the current administration is the disconnect between what is in law that we've agreed to versus what is in practice today, and not having the appropriate checks and balances to make sure that we're doing the things that we need to do. And who's harmed by that is people with disabilities and their families. Funding is a significant issue for us. We're all aware of the cuts to Medicaid that are going to be coming as a result of the passage of HR 1. Medicaid is the only funding stream for people with significant disabilities who require long-term services and supports to remain employed. So we know that those cuts are on the horizon unless Congress does something different in the interim before some of those provisions in HR 1 are enacted. But fast forward to this week where we are, reeling from news of really the decimation of the Rehabilitative Services Administration. Wow, what a horrible month, that no one at RSA can answer a phone or an email during National Disability Employment Awareness Month. It just is unconscionable. And yet here we are. Fundamentally, the right to work, it is a civil rights issue. It's something we need to be paying attention to for a lot of reasons, but we're stuck. And I think something that we need to contend with, and maybe this will come up later in conversation, is how do we get back to, I don't even want to say that disability policy has historically been nonpartisan. Quite frankly, disability employment policy has been bipartisan, and we need to get back there. We are not there now. And so I'll just pause there in the interest of time and knowing we have other content to cover today.
Thank you, Dr. Christensen. I'd like to, for a moment, and what a cruel irony it is that our conversations around disability employment come during the month of October, National Disability Employment Awareness Month. But I know that there has been a very specific area where strides have been made, and there is hope for the elimination, and that is as it applies to Section 14C of the Fair Labor Standards Act. And this act allows workers with disabilities to be paid less than their non-disabled peers and even less than minimum wage if their employers hold a special certificate allowing them to do so. Can you talk about why it's important to phase out 14C and what progress has been made towards that goal, and what this administration is doing to either help or hinder those efforts?
Sure. And again, I want to thank Congressman Scott for your leadership on the Transformation to Competitive Integrated Employment Act, which we've been working diligently to try to get across the finish line for several Congresses now. I think it's hard to talk about 14C without recognizing history and context, but we only have an hour, so I won't bore you with the history lesson. But the reality is that 14C exists out of a recognition that veterans returning from war who suddenly found themselves with profound disability had a right to be retrained to enter back into the workforce. That's what 14C was intended to be. Fast forward in 2025, it's a system that, quite frankly, holds back and what's the word I'm looking for? Really targets, for lack of a better term, people with intellectual and developmental disabilities for whom the law was never, or it was never intended for that. It's based on a flawed assumption that people cannot work, which we just know is absolutely untrue. And it's one of the few situations where there is a loophole in law that says you are a person with a disability, therefore we can discriminate against you. And that violates everything else that has come since 1938 when 14C first started in terms of our civil rights laws. And we need to close that loophole. And so, I know a lot of work has been done at the federal level and leading up to the notice of proposed rulemaking, right, that was announced right at the end of 2024 to relook at those rules for 14C and potentially cease the use of 14C certificates. Unfortunately, that did not make it through the process, and we had a change in administration, and so the Trump administration has rescinded that rule, and so there is no forward movement at the federal level beyond the Transformation to Competitive Integrated Employment Act, which we are working very closely with Congressman Scott's office and other offices to get this over the finish line. In the meantime, it's states that are really picking up the slack. So 17 states have passed legislation to phase out the use of subminimum wages. I would argue that the states that haven't done it yet are unlikely to until the federal government tells them they have to, which is why the TCIEA is so critically important for us to move across the finish line. But it is increasingly difficult to move this forward because for whatever reason, we are in a situation where, and I would argue that it's part of the moment we find ourselves in, doing common sense legislation is difficult to do when two sides won't talk to each other simply because it's two sides, right? And I on the plus side, and again, kudos to Congressman Scott and his staff, this is a bipartisan and bicameral bill. But somehow we need to figure out how to move across the aisle so that we can get this across the finish line, because it is common sense legislation. It's not about what's right to do, although that is absolutely important. But paying people subminimum wages simply because you are a person with a disability does a disservice, quite frankly, to our country. It limits our ability to really capitalize and build on the talent pool that is workers with disabilities and what they can bring to our economy and to our workforce in ways that we haven't even imagined because they haven't been given that opportunity.
Thank you so much. You touched on so many things. One of them, though, that really strike close to home for me, being it part of RSA previously embedded in the Department of Education, is the notion about the empowerment of states. And so, Ms. Almazan, I wanted to turn to you and talk about the administration that has consistently asserted that what it wants to do is return control of education back to the states, including proposing to eliminate certain federal requirements, as well as to block grant IDEA and other education funds.
Mhm.
Additionally, the department counseled more than 18 million in grants under IDEA Part D that strengthened the special education system. And we've all heard about over the weekend, nearly everyone in the department who worked on special education. Can you discuss why it's important to maintain a federal role in implementing the IDEA?
Right. Thank you. Well, a bit of breaking news before we go on. The federal judge in the lawsuit that the unions brought for the most recent RIFs on October 10th, the federal judge just issued a temporary restraining order blocking the RIFs that happen on October 10th. That's all that I know. I got the email while we were in discussion. So that is a bit of good news and does show that the courts can still work to protect civil rights and equity. Getting to your question, COPA has opposed any block granting of federal education funds, including the IDEA and ESEA federal funding, formula funding. The administration's actions, which included a budget proposal this year to block grant much of ESEA as well as IDEA preschool funding with critical funds for national activities that were authorized under Part D of IDEA, would have flouted both current law as well as critically jeopardized family and children access to early intervention services, which we know are critical for students just early on in their education career. Student and school district access to assistive technology, parent and guardian access to parent training and information, and state access to technical assistance on evidence-based practices and more. Thankfully, and largely due to COPA's advocacy along with important partners in the education and disability community, neither the House nor the Senate Appropriations Committees adopted the budget proposal in the respective fiscal year 2026 bills awaiting action. It is critical to continue to have federal oversight for monitoring states to ensure that states are doing what they are supposed to be doing in order to ensure that students receive critical services. Without monitoring and oversight, there is great concern that states are not going to uphold what they are supposed to do under IDEA, what they are supposed to do under Section 504 of the Rehabilitation Act. I can't stress it enough how important the federal oversight is. Flawed as it may be at times, it is still important to for states to have access, not just to the oversight, but also to the technical assistance that the federal guidance brings to states. COPA filed a lawsuit when back in March of 2025, when the 7 out of 12 regional offices of the Office for Civil Rights were closed. We filed a lawsuit with the National Center for Youth Law and Southern Poverty Law Center challenging the administration's actions, which decimated the Office for Civil Rights. The Office for Civil Rights is an important piece of federal guidance or federal authority to ensure that students have their civil rights respected in schools, which you don't need a lawyer or an advocate to file an Office for Civil Rights complaint. You can go online, a parent can fill it out, and a parent can say, I think my child has been discriminated against because of a disability, because of the intersectionality, perhaps of race, disability, sexual orientation, trans status. And that has been really ripped away from families. I talked to so many families in the spring of 2025 who are devastated that their complaint was now out in the ether. With these further reductions from October 10th, 2025, it is unclear whether or not more staff at the remaining Office for Civil Rights offices that remained intact, whether or not there's even staff left at those OCR offices. So it is important to continue to have federal oversight for families. Families rely rely on access to the OCR. They do. And you don't need anyone to help you fill out that form. And families do that because when they're faced with what they perceive to be discrimination based on disability, based on race, based on sexual orientation or status, it is important for them to know that there's somewhere where they can go. They don't have to go to court. They don't need a lawyer. They don't need to pay money for a lawyer or an advocate. They can do it on their own. And that was their safety net. And that's not there anymore. Thank you.
Thank you so much for that. Want to turn to health really quickly. I know we're getting close to time. Ms. Prangley, the Trump administration has taken numerous actions that erode the supports and services that enable people with disabilities to live and work in their communities, including cuts to Medicaid and the reconciliation bill, the dismantling the Administration for Community Living within HHS, and proposed cuts to a variety of disability programs within Health and Human Services. Can you talk about how these actions harm people with disabilities and how your organization is responding to these multi-pronged attacks?
Thanks, Dante. So I don't want to repeat what other panelists have said too much, but yeah, Congress, stunned us this year by breaking its 60-year promise with the states that it would be a partner in Medicaid, by saying to the states, with no real deliberation or discussion among the governors or the state Medicaid directors whether this was possible, they just said, you know what, we're going to use reconciliation and jam this historic cut down your throats, and you guys can figure out what to do with it later. Again, state councils on developmental disability, we advise governors. Our members are appointed by the governors. What have we done? We met with the state Medicaid directors. And let me tell you, if you staff have not talked to your state Medicaid director about what they're going to do with this change to Medicaid, I strongly urge you to do so quickly. The councils are telling us now that there is not a single state that knows how to implement work requirements. There is not a single state that knows how to fill budget gaps in essential services that are created by this. There's not a single state. I say this with authority because our councils have been working with the Medicaid directors to find out, where is the solution to this? What is going to happen? This was done with intention. Congress knew that Medicaid isn't just about healthcare, although we know that these changes will kill literally tens of thousands of people. It's also about the community-based services that Julie talked about a bit. It's also about Medicaid in schools that I know Celine has been really strong on. These Medicaid services that allow people to live, work, and thrive in the community are also at risk. Congress is literally threatening the independence and dignity of Americans with disabilities by passing this, and the states have no idea how to implement it. So I want that to sink in. This has to be dealt with by Congress. You all need to come back and figure something out, because this is going to fail. And the timelines that Congress has put in place to kind of, avoid the fact that this is going to fail by phasing in some of the changes. So we're not going to realize the Medicaid cuts until after the next election for all of these political reasons. It's going to fail. And there's an acknowledgement at the state level that it's going to fail. So please do think about you talking to your state folks. It'll make you feel better. Inside the Beltway, we get angry. We don't understand what's going on. Talk to your state folks. Understand these are good actors, red, blue, and purple states. None of them know how they are going to fill these gaps in Medicaid. They're all very, very afraid. Shockingly, the administration has also proposed additional budget cuts, some that have been discussed by the panelists. The ones that affect our programs, the state councils on developmental disabilities, we saw leaked documents in summer, which would have eliminated the state councils on developmental disabilities, which would have eliminated the University Centers on Education for Developmental Disabilities. These are programs that go back, as I said, 50, 60 years that states rely on to help fill gaps in services. DD councils provide grants to nonprofits to do model programs in places like employment. We've worked with Julie's groups. We've worked with education professionals to fill these gaps. They were just going to eliminate them. But we applaud Congress in one regard, and Celine mentioned this. we're starting to see bipartisan backbone when it comes to these programs. When it comes to standing up in the appropriations field, they did stand up for the disability councils in the appropriations, and both the Senate and the House are now, and the committee reports have them both funded. So there is opportunity for Congress to exercise its constitutional authority under Article 1 and say, wait a minute, Mr. President, you can say all you want, but these are the programs that keep our country moving. These are the programs that are important to our constituents, and we have say when it comes to which programs are funded and what levels they're funded at. We need to encourage our bipartisan work on this. As I said, what I found very effective is having our staff talk to their state Medicaid directors, talk to their state education directors, and let them hear not only from constituents but from the states that what this burden shift in terms of funding is not sustainable. You can't create a system over decades where states are asked, where states and federal partners are real partners and just get rid of it in 1 year without any testimony, without any hearings, without any consideration for the lives of the individuals who will be impacted when the states know they cannot fill those gaps without federal support. Finally, I just want to say, I know we're going to do questions. I just want to say, civil rights are disability rights. Civil rights are disability rights, right? So whenever Congress goes back on its word to support programs that serve marginalized and low-income communities, it is always a disability issue. One of my main frustrations with congressional staff, sorry guys, is that I ask, when are you going to listen to the disability folks? And they say, well, Erin, well, as soon as we have a disability law, we'll come back and ask for how that's going to affect you all with disabilities. Please take this with you. Civil rights are disability rights. When you are talking about SNAP, make sure that people have food, you are talking about people with disabilities who, because of their disability, have nutritional needs that will not be met if you take literally food out of children's mouths. When you're talking about education, you are talking what Celine talked about. You are talking about taking away educational opportunities that didn't exist in my lifetime. I already shared with you, I didn't go to school with anyone in a wheelchair or anyone with an intellectual disability. These are hard fight rights that will disappear. It's not, any civil rights are disability rights. And then I have all these examples, but I know that cutting programs is not just a budget decision. It's a decision that affects real people's lives and their dignity to thrive. We've got to uphold those essential services. Civil rights are disability rights. Please include us in your conversation. We're happy to provide in-state examples. Thank you so much for your time today.
I greatly appreciate your response. And the thing that strikes me the most is the level of intentionality that goes into breaking these systems, combined with the confidence that you express that there isn't a single state that has a solution that can appropriately address what we all will very soon be facing. And so when you talk about the overlap of the problems that are being created, how, and this is for everyone, how do you think the disability community can collaborate both within the community and with other civil rights organizations to push back on this administration's attacks? I'll open that up to anyone who wants to answer.
Well, I'll jump in, and Erin and Phoebe at least know me well enough to know, kind of where I'll head with this. And maybe this is a little bit of an unpopular opinion, so to speak, but I think the disability community itself needs to do a better job of working in a bipartisan manner. For a variety of reasons, in recent years, these issues have felt partisan in ways that historically they never have been. And, I know my organization and Erin's work are working very closely on the Transformation to Competitive Integrated Employment Act to eliminate 14C. And, and again, we have to embrace cross the aisle dialogue. I think there are ways to talk about what it is we want and need that can resonate with people who may be coming from a different perspective. And we sometimes lose sight of our need to translate at times, and get caught up in kind of the emotionality of it. It is emotional. It has felt very much like, as a disability community, that we're under constant attack. But we're not going to make progress if we don't model what we need to see from our government, which is the ability to work with multiple perspectives and come to agreement on, what we need to do to move forward. And I think that's been a challenge recently.
I know that COPA has worked across the aisle on different pieces of legislation, particularly the Keeping All Students Safe Act, and trying to work with everyone, all senators and congressmen. We have reached out to this administration early on to meet with them, to talk about what our issues are, in an effort to work with this administration. And we continue to do so. And I understand that in the first Trump administration, we were involved in legal action against the administration for actions at that time that were unlawful, and we prevailed. And while we have legal action right now against this administration, we always stand ready to talk with them about what our concerns are regarding students with disabilities. Because one of the outcomes of the IDEA and education of students with disabilities is that at the end of their school career, they are ready for employment, independent living, or post-secondary. So it all meshes together, all of these interests, whether it's employment or education K to 12. I do think that Congress has to work actively to protect the appropriated funding and continue to resist any efforts to shift the responsibilities of IDEA and ESEA and other education laws away from the Secretary of Education. But we do stand ready to work with the administration and across the aisle. And I will just tell Aaron and thank you for the characterization of disability as civil rights, because it is. I teach a class for COPA, a 12-week course, and I teach our students about civil rights and about why disability rights are civil rights, because it is about equity at the end of the day. So thank you.
I don't know if there are any questions. I'm really interested if there are, and I know we're short on time, but I will say, staff, you're looking for answers. You're looking for where's the disability community. Start thinking about your state actors. A lot of the leaders in this, and a lot of the voices in this community are not being heard because their voices in the states. I think that when I talked about, it's not a coincidence. We saw this attack coming from the administration. They meticulously planned as well. They serendipitously are taking advantage of a president who, they are serendipitously taking advantage of an administration that is open to turning back the clock on Medicaid and other things so that he can pay for tax breaks for rich people and other things. He's open to those ideas. That's serendipity. But there are people in the states who've been trying to roll back rights for years, ever since. They will always be there. And where are your strongest advocates, your smartest people? They're not always, it's not me in Washington. It's going to be those folks in your states who continue to organize. The state of disability advocacy in the states is strong. Our people work with APSI on 14C on state legislation. Our people work with COPA on state education legislation. You will find your best friends and advocates by working closely with your state Medicaid directors. And if not, if you don't have a state Medicaid director that supports you, then find your state ARC, find your state APSI, find your state DD Council. And we're here to help make those connections so you can make those arguments to your members of Congress to keep them on target. Don't let them cave into this pressure to have to be one side or the other. Be on the side of your constituents and the disability experts in your states, because the state of disability advocacy in your state is strong.
Thank you so much to our panelists. We do have a hard stop at 3:30. I wanted to extend my thanks though to the House Committee on Education and Workforce, specifically Congressman Scott, as well as to staff Phoebe Ball. Really want to express my appreciation for everything that you've contributed here, and let's take the example of coming together to address these issues that aren't exclusively based on individuals with disabilities, but greatly impact our community. Thank you.